Yep.
Oh, that's us.
This is the legend.
All right, it's time for Stan Pierchoski. He's here already.
Good morning.
Good morning.
Good
Is that headphones up nice and high for you? Because he always turns them
No,
up.
not too well, a little bit. His head's bigger than mine too.
Gosh.
He must have greater cranial capacity.
Well, he's like me. He's got the big head. So there you go.
Big
Stan, how are you, man?
I'm good. Missed you last week.
Missed you last week, but
we trudged through it.
trudged through it. But I did get to come to your seminar.
You did, and that was a week ago.
Yeah, Teresa and I came, and my daughter and son-in-law came.
Did they? Okay.
Yes.
Well, I mean, I hope your opinion's not biased, but if you want to tell the listeners what you thought of it.
I thought it was absolutely fantastic.
You hear a lot of that.
I told your wife, I said, I've been with Stan long enough that if he ever needs me to fill in, I could do that seminar for him.
Yeah, probably. Might not get in the right order, but you can do it all.
With the PowerPoint, I think I could just go right through it. But no, if you haven't been through it, it's very informative, and I would encourage somebody to do what we did. We called my daughter, my grown daughter, and son-in-law, and I said, this is happening, and get the family involved, and get them to see and hear what we get to see and hear about your estate and estate planning and what can be done to plan for that.
That's everything in a nutshell. Is there's options. There are options.
Yes.
I'm betting most people, if not almost all, haven't heard them because they're not available. You can't find them on the internet. If you do, they screw it up so much you can't understand it or it doesn't sound right.
Yeah.
But there are options to do, and they're pretty good options. They're pretty good. It runs the whole gamut of estate planning, whether you're doing pre-planning like the trust that we talked about, or if you're in some sort of crisis thing. We were talking about a little bit of that off mic about a crisis situation, and they all kind of work together. I mean, if you pre-plan, it makes when you're in crisis, it makes things a whole lot easier.
Yes.
But if you're in crisis and didn't do any pre-planning, there's still things that can be done.
Yes.
So it is. I think it's worthwhile, and that's why I started doing it. But I've been doing the seminar for 10 years.
Yeah.
When I first started doing it, I would get people that come in and say, "I want to do a will."
Yeah.
I'd say, "Great. Would you like to hear about other options?"
Yeah.
And I'd usually get a response like, "I didn't know there were any other options. I thought will was all you could do." Something along those lines. And as soon as I start talking about the other options, you could see the people gravitating toward that because they're better options, right? Yes. And so I thought, I ought to have to do these seminars. Now, I first started them. Didn't get much attendance. We just kind of, I don't even know how we advertised we were having them back then.
Right.
But, we started doing something. We started getting people coming, get a little bit of word of mouth. We talk on the radio now. And, now they're very well attended. There's probably 60, 70 people there.
Oh, yeah. We had a great crowd and a good facility here to do it. And, of course, your next one will be at the Star Theater.
Yeah, and that's and we don't just do these two counties, but it seems like lately we have, and because the girls keep the calendar, they set those things for the year, or at least 6 months ahead of time. But we typically do them every other month. Now I do some kind of private ones. Sometimes people invite me to talk to their employees or church or something like that, and I'll be glad to consider that if I can work it in the schedule.
Yeah.
But the next one's September the 12th. And that's a Saturday too. And that's going to be at the Star Theater in Pulaski.
Yeah.
So
we'll give people plenty of notice.
Yeah, and I mean we had enough engagement at that one we just had. It'd probably keep me busy till then.
I was going to say, you had several people look like they were signed up for that initial meeting and all that kind of stuff.
You didn't get a chance to stick around for much of the question and answer, did you?
No, we had to go, but I knew you had question and answers, and some of them coming from some of my buddies that were there.
Yeah, and it was we did a lot of them. It was pretty good. I always love the question and answer period.
Yeah.
It's just lets me know where people kind of are, the thoughts that they're having about things, and it's always the fun part for me. I just get a little tired of standing after a while. I can't stand as long as I used to.
You need to get you one of those tall stools where you can.
Yeah, right. Well, I could sit down. Sometimes if somebody has a question, I'll go sit at the table and just chill out a little bit. But it was a great seminar. They always are. And it's always good people, and the people that show up are the people that want to hear something about this.
And I got to have one of the muffins.
There you go. There you go. Only one?
Only one, yes. I didn't want to, overstay my welcome on that. So
the last time we did one, Miss Tammy was down Miami helping my daughter have her third child. They're all now here, but that was back then, and I had to take the cheap way out and go buy donuts. I mean, I can't make them. Nobody else wanted to make them. Yeah. So I do donuts. That was the one we had at the theater. But I mean, it's something. But I like to have the homemade.
So how are the grandbabies?
I think I've selectively forgotten what it's like to have small children in the house. I mean, it's great having them. It's a little noisier than I remember.
Yeah, I think that's the thing that gets me. We go to visit Missy and Brad.
Yeah,
and,
yeah.
and of course, they got two rambunctious boys, and the noise. So we're not used to the noise.
Do you experience this? It's like they'll be playing together.
Yeah.
And they go from 0 to 60 in like 2 seconds where they just hate each other. And then 2 or 5 minutes later, you look over and they're just playing together again. It's like it's just like a cycle, back and forth and back and forth and back and forth. You never know what's going to set one of them off. You know, it's just, and they get mad at each other.
But it's a joy all the time.
It is.
Yes.
It is.
Yes, it
It's
is.
nothing better when you show up or you're getting ready to leave and they come up and give you a big hug and you know, bye or something.
It melts you down.
Yeah.
It sure
You know,
does.
and the one that so we got a almost 5, almost 3, and a 1.5 month old.
Yeah.
Brand new. And she's a little colicky and stuff.
Yeah.
And so we pass her around a lot at night. Seems like every night for about an hour or two because
Oh yeah.
it just breaks your heart to see this poor child cry and there's nothing you can do about it.
Oh yeah. We don't want them crying. No.
But you know, my wife used to say, if when the kids are driving you crazy, you know, you think, oh, I'm just going to kill them, right?
Yeah.
She said, then you can go look at them and they're laying there asleep, right?
Yeah.
And they're asleep. And she used to say, God made them just cute enough that you won't kill them. And you see them laying in bed, it's like, oh,
Yeah,
it looks so
yeah,
sweet.
yeah.
And your mind just completely resets.
That's
And
right.
then you go through it again in the next day.
Well, little John Daniel, he was at the house a few days ago, and so last night, this just happened last night. I looked over and we've got a mantle, and I saw this little brown thing. It looked like one of those July fly shells, you know, that they leave on a tree.
Yeah. Oh, yeah. Okay.
And I walked over there and I said, "What is that?" And I picked it up, and I could tell it's a little bitty piece of dried toast edge. Okay.
Yeah.
So I told Teresa, I said, "Come here and look at this. Why is this up here?" Well, there's a chair close by there. She said, "Oh, that's where." Now this is how Teresa is about this baby. That's where John Daniel was eating toast in that chair, and he put that up there. She said, "I'm gonna leave that there." Just because she thinks it's cute that he put it there for some reason.
You know, I got one. I put a gate up because I got stairs, and one 2 almost 3.
Yeah.
His boy,
Yeah.
and put the gate up for him because he likes to go up the stairs without anybody going up there with him. And,
Yeah.
whatever. And so I put a gate up. Well, my daughter, who's the mother of the children,
Yes.
she said, you know, Luke has he gets through this hole right here under the railing.
Yeah.
I said, how do you figure that out? She said, well, I know. I came in, he had his stool. He had this little stool that they can pull out with it when they stand at the kitchen counter with grandma or something and make something. He says, yeah, I saw him. He said, when you see a 3-year-old walking around with a stool, you know he's up to something.
Yeah. He's up to something.
He's
That's
trying to
right.
scale something, right?
Well, you know, to tie this into what we do, it's all about family.
Oh, man.
It's all about family.
Yeah.
Our families are important to us, and so what we leave to our families and our loved ones, or those that we want to leave to, is important.
You know, when you have those little kids like that, when you see them in those solemn moments, I mean, your internal thought goes. I'm sure you've had it. It's almost like I would do anything for this child. I would do anything to protect this child, make sure this child is safe and comfortable and it doesn't get hurt or just whatever is necessary. Being a grown up, you just have that instinct.
That's right.
It's overwhelming, that instinct. It's just a flood of emotion that's that strong.
Sure, absolutely.
And in the moment, if moment presented itself, most people actually would. You know, I wouldn't even think about it. But you're right. There's this natural emotion that you have that you want to take care of family.
Right.
And so when you talk about estate planning, of course, we're talking about taking care of after death.
Right.
But you know, death can come at any time. You know, if it's old age death and you just want to leave them something as inheritance, that's what most people think about with estate planning. But estate planning can also come with an untimely death, because now it's like, okay, you're not here anymore, but what's the next best thing? The next best thing is for something to at least step into your financial shoes and provide that support. You know, so there's all kinds of instruments you can do with that. One that comes to mind is like life insurance and stuff. But but you're exactly right. When you do estate planning, for the most part, you don't really do it much for yourself. You do it for the people you care about.
That's right. Exactly.
Now, except for things like some of the asset protection and long-term care, we kind of do that for ourselves so that we can protect our assets. But in the long run, we're doing it for them, so we're protecting it so it can go to them.
That is exactly right.
But at the moment, you're protecting it from your creditors during your lifetime so that they don't get it.
That is true.
But the reason you want to protect it is so you have it to pass on,
Well,
or using your retirement.
and we touched on it earlier. There's so many of us that do not know the options.
Yep.
That do not know what can be done. Yeah.
And I don't nobody at fault for not doing that. It's a big deal. You got to go out of your way to try to learn the stuff. You got to look for it. You got to find it. You got to read it. You got to understand it. That sort of stuff. And so the average person can't, because just don't. Life just gets in the way, just like it does for me.
Well, for so many years, we've been preached to about make sure you have a will.
Mm-hmm.
Make sure you have a will, and that's all we heard. And if you did hear of a trust, you thought it was for the elite or the very, very well off.
Or just, I have some people say, I heard about trust, but I just don't really know.
Or don't know what it
does.
Don't know what it does. That's right.
But you're right. But I want to tell a story.
Okay.
It's something I experienced just this week, and it prompted me to want to do a little research. I got a call from a fellow. It was a little bit of a lengthy call because there's a lot of facts involved, but it prompted me because I never had anything quite like it, and it made me think, gee, I wonder how this would work out. I thought I'll give you a hand. I'll do a little research. So what it was a fellow called me. I'll kind of give you the facts succinctly. There was a husband and wife. Okay.
Yes.
Husband passed away, I think, in 1995. Never was in long-term care, just passed away. But he passed away, and then did not have a will. But when the first death of a couple, it's usually no need to do any probate because everything's jointly owned. And the house passed to the wife by right of survivorship, right?
Yes.
And now that was in 95. Well, in 2008, well, a little before that, 2005 or 6, the wife went into long-term care.
Yes.
And she was in long-term care, and she had an attorney transfer the real estate, the house, or what we call the primary residence. If I say the home, I'm talking about the primary residence.
Yes.
And had that transferred to her and her son with right of survivorship. Okay, which you can do, but you have to actually have the deed that says those words. And they did that somewhere prior to her death. And then she passed away in 2008. Okay, now 2008 is, 18 years ago, 17 years ago?
Yeah.
Okay.
Yeah.
So she passed away in 2008. And I was digging through the probate archives. And the person that called me had some of these documents he sent them to look at. And there's a TennCare claim, an estate recovery claim. Okay, actually, TennCare actually opened the estate. Trying to piece it together, I was talking to one of the sons, and he's trying to tell me what happened, but it didn't sound like mom had much other than the house at her death. Maybe a little money in the bank, but she was in care. So we know she didn't have much, because if she was in care, she would have had to get eligible.
Right.
And to get eligible, she couldn't have much money in the bank.
Right, exactly.
So she didn't have much money, but she had the house. And we know the reason they didn't go after the house when she became eligible back in like 2006 or so is because the primary residence, the house, is an excluded asset. Don't confuse that with exempt.
Right.
It's an excluded asset. What that means is it's a countable asset, but they will exclude it during the eligibility process. So, and he said this house is probably worth $100,000.
Okay.
So if you exclude the house, it's a countable asset. So you got $100,000 of countable assets, and you're only allowed to have two, right? 2,000. So if you can't do anything with the primary residence, wouldn't that mean that you are always $98,000 over resourced? I mean, it would, right?
Well, it sounds
the
like
house is a countable resource, and you only can have two. You're always going to be over resourced with this house. But if it's the home, the primary residence, you can exclude it. What excluded means it's a countable asset, but we're going to take it out of the countable column and put it in the excluded column. So we just lowered our countable assets by $100,000. Okay. Now she was eligible, right? And so she qualified. TennCare paid the bill for, I don't know how long she was there, about 2 or some years, maybe not quite, but she and then she passed away. Now the estate recovery, every state's required to have an estate recovery program. Ours is just called TennCare Estate Recovery.
Mm-hmm.
And it's a program where they can now go after any assets in your estate. Now, remember that house. It didn't go anywhere. She still owned it.
Yeah.
They just didn't use the value of it against her for the calculation of her eligibility when they wanted to see what resources she had.
Right.
They excluded it, which took that $100,000 out. Ownership didn't change. It didn't go anywhere. Still hers. Now it's right for them to come after death. Okay? And that's what they did. But they kind of did, but they didn't. So here's what happened. I think it was in 2008 or 9, apparently a probate was never opened by anybody in the family. So
Okay.
10 Care opened it. And they can do that. Creditors can open estate. What they, if estate, creditors' rights expire 12 months after death. And
Okay.
here's what this I know this from when I used to do probate. Remember I mentioned I don't do it anymore.
Right.
But when I used to do probate, if somebody says, well, I'm just going to sit on my hands and not open daddy's probate till after 12 months, then the creditors can't do anything. Well, it's not that easy. Usually about 9 months or 10 months, you get a letter and says, hey, if you're not going to open a probate estate, we will, because we don't want to lose our rights.
Yes.
Your deceased owed me money. Well, 10 Care is a creditor, and the 10 Care had a claim of like $97,000, $91,000. The bill was like $91,287.19. So it was like, it was right down to the penny, and they had 18 pages attached to it that tabulated all that up. Anyway, so 10 Care opened the estate, and they filed their claim. Now, I asked the guy, whatever become of this? He said, I don't know. My brother still is living in the house now. And, said, well, I remember when this came out, but nobody's ever done anything. So here we got a situation where 10 Care made an estate, a probate estate. They made it timely. Well, it was certainly timely because they opened up the estate and the first thing they did was file a claim, right? So they definitely filed it within 120 days of opening the estate.
Mm-hmm.
And as far as I can tell, it was the only claim. Now, I thought, how could this probate case have been closed? Because for a probate case to be closed, you have to file a 10 Care release, which is what told 10 Care she was passed away, told them to look to see if they had paid any money on behalf of her, and was what had them find out that that was the case, so that they turned around and filed the claim. And that's why the probate process makes you file a request for a 10 Care release. That triggers them to see if it's somebody that owes us money.
Right.
Now, here's another let me divert just a little bit to make sure that listeners understand, because this shocks people, sticker shock big time. When you get somebody eligible for 10 Care, like we got your father-in-law eligible at some point,
Right.
It seems like most people think, well, he's eligible now, they're going to pay, that's the end of it, right? People, you didn't know that was a loan, right? You didn't know that they were going to pay all this money for this person, but at death, they want paid back. Did you know that? Most people don't.
Most people don't.
So I say loan, but I just say that as best thing I can think of is they pay all this money on your behalf. So, let's say you got $10,000, your bill's $10,000, your income is $2,000. That goes to the cost of care. 10 Care will pay the balance, so it'll be somewhere around $7,000, $8,000, right?
Mm-hmm.
Well, if you live for 2-3 years, they keep track of all that. I just told you on the claim I saw was 30 pages, and it itemizes everything, and then they pay all that, then they'll send an estate recovery claim for, like, in this case, $91,000, because they want it back. They want back what they paid that person.
Yeah.
Which shocks a lot of people. You talk about sticker shock. So it puts some people over the edge, and it's like, I thought once 10 Care decided to pay, they just paid. It's a program that pays it for you, right?
Yeah.
Well, 10 Care needs a way to operate. They have to recover money, and that's how they do it. And so that's what happened here. 10 Care has a claim of $91,000 because that's what they spent on this gal for the time she was in care.
Yes.
So they filed the claim. It was timely filed. It was properly filed. The probate was opened it was opened in 2009, and nothing was ever done. And so I went to the archives. It was over in Giles County, and I went to the archives and looked at it. And the probate estate was never closed. It was retired. Now that means not closed, but kind of shutting it down for now. What happened was, in most counties, about every 3 years, they can do what they call a docket call, where they go through all the cases. And if they flag any for inactivity, like no activity for the last year,
Sure.
they get a hold of the attorneys and say, look, this is coming up in 2 months for a docket call day. You have to respond to this. If there's file a motion. If there's any reason to keep this open, file a motion and request the court to keep it open. If not, and you don't show up, the court's going to close it.
Yeah.
Dismiss it for inactivity. Well, this one, I don't know exactly how they did it 18 years ago, but if I was certainly practicing law back then, but that was back when I was doing something else.
Yeah.
And so they retired it. Now, a retirement is not a closure. You don't close the estate. It's just kind of like put it on the back burner.
Yeah. It's kind of put
not
on
sure
hold.
not sure how it got there, what the process was, but that's what it did. And so I thought to myself, okay, they're a creditor, right? I mean, let's not call them 10 Care. Let's just look at them in legal terms. They're a creditor.
Right.
And they have a claim. Any creditor out there in the world that's a claim against somebody, there's a statute of limitations for that to wear off. It's a debt they're trying to collect, right?
Yep.
Now, the statute of limitations to try to collect the debt is 10 years.
Yep.
For everybody else. And so I thought, surely to gosh, 18 years later, and this is what got me thinking. I thought, I never had a case where there was a valid claim, apparently valid at the time, that was that old and they didn't do anything with it.
Yeah.
And I thought, well, it wasn't during COVID because we're talking about back in 2009, right?
Yeah.
They can't blame it on that. So anyway, I got looking at it. I didn't piece all the pieces of the puzzle together, but because the archives didn't have some of it, so I don't know what happened, where documents go when that happens. But, it turns out it's still. I did some research on the statute of limitations on that, and there isn't one. It's still a valid claim. The only statute of limitations we have on TennCare debt is the timing about when they can file it. If they file it in time, it's a valid thing. The statute is completely silent on an outer end. Now, could I go take it to court and say, hey, everything else in law has a closure, so this should have a closure too, and 18 years is surely past any expectation of. But here's the thing: it's a valid claim. The house is still there, and when they go after a house, they just sell it. That's why they were calling me. They wanted to keep the house.
Well, does the okay? So does the son that's on the deed, is he not?
Well, it went to him because he was right of survivorship. He's actually in long-term care too.
Oh, okay.
But the claim happened from when the mother passed away.
Right. Okay.
That's where the claim attached. It may very well have a second point of attachment with the son that's owner.
So in this case or something like this, is the state trying to force a sale on the house?
No, they never have. That was what got my attention. Why wouldn't they have not ever done that? And they're not hanging on to it for the son because the son doesn't fit. The son's not underage, a minor, or permanently disabled, or somebody that they don't go after the house if somebody like that's still living in it.
So if he passes, then what happens?
Well, then it's he's right of survivorship, but he's the last survivor, so it just turns out to be an asset that would go to his heirs if he has a will.
Okay.
Or, but it will certainly be exposed to his long-term care business.
I was going to say once if that happens and his heirs sell the property, then they're going to collect anyway.
But I mean, that's right. That's right. And well, if they don't do what they did on this one, so I'm at a loss as to why this just sat there doing nothing.
That is interesting.
There was a house for them to go after. When I did probate, they would go after them.
Yeah.
Now, they'll negotiate and let you buy it back. God bless them. They'll say, we got this $91,000 claim. If we sell the house, we're probably only going to get $70,000 for it. Plus, we got to pay attorneys and auction people. And so we'll only end up with 55 or 60. So you can buy it back from us for 60,000.
Yeah.
And they'll do that. They'll entertain that kind
of. And that might be a smart move.
Well, if you want the house, at this point, it's the only move.
Yeah.
Buy it back. Yeah. But, which means you're going to inherit the house, but you're going to only inherit half of it and pay for that. But
wow.
So anyway. I thought the interesting point was, and it's not. I think it's not so great interesting point. The TennCare's liens have no expiration.
Yeah, that is an interesting.
If they properly file the lien, then I thought I'd do a little AI on it. Now I do AI. I really take it with a grain of salt.
Mm-hmm.
But what AI is good for me if I'm looking for something, I'll say, what's the statute that governs this, and it'll spit out some statutes. I'll go look them up. Some will be a little bit off point, but then very likely we'll get one that either is the one I'm looking for or points me to the one I'm looking for. You know what I mean? And so it's very helpful that way. But I even did that, and it pretty much came back with exactly the determination I came up with. There's no, can they still collect? Is it a valid debt? And, probably yes. Absent something I can't find, which I can't find it because I know where it would be if it existed.
There's no expiration on it.
Most other debts out there, and of course, when it's the government, you usually get special treatment, but not treatment where it didn't exist at all. In other words, if normal statute of limitations on a debt is 10 years, they might get 15 or 20 or something because of the state or the government. They get more, but I couldn't even find that.
I've run into that before with a deed of trust, where
that's the mortgage, right?
Yeah. It sat dormant for so long, and so there is an expiration date after so many years. It just goes away.
Yeah, the bank's debt they've got to deal with it, and there's quite a few laws that govern that. Quite a few time frames they can do.
Yeah.
There's a 2-year right of, I forget what they call that, right of recourse, where the actual owner can restore it up to 2 years after being in default.
Yeah, I didn't know that. That's
I mean, it's I forget it because I don't do much of that. It sounds like stuff I studied in law school for the test.
Jeez.
But I thought that was interesting that you know, that is that powerful, that debt. But I'll tell you what, when I tell people that, when people come to me and say, hey, hey, Gertrude eligible for 10 care years ago, and they've been paying the bill for it. Now we got this bill for $150,000, $250,000. What's that all about? When I tell them they want paid back, they're just shocked, So I try to say that to you so you are aware that that's possible.
And what happens, of course, they won't pay back, but if there is no assets to pay back,
Well,
then
then
it just goes
the
away.
estate is insolvent.
Yeah.
But, and they'll still file the claim, but if state's insolvent. See, that's why, if you remember, I mentioned in the seminar, there's two things that we always plan around when we're doing planning. It's always right on the front lobe of our brain, so to speak. And that is the gifting that gives the penalty period, right?
Right.
And the other one is estate recovery. So what good does it do you to shield an asset during life so that it's not available? Like this primary home is an example.
Yes.
You can shield it for the eligibility process because they'll put it in a different category, not
Yes.
use it against you. But when a death, estate recovery comes around, they take it.
Yeah.
Here's what people tell me, and I'm not saying all nursing homes, but a lot of them. People come to me, and their loved ones in a nursing home, and they tell them, they say, "Don't worry, their house is protected." I've heard that over and over and over and over. The house is protected.
Yeah.
Object to the word protected. I think the proper word is deferred.
Yeah.
They're going to take it. They're just saying, we're not going to take it yet.
Yeah.
And if you pass away and your spouse is still living in the home, God bless us, we won't take it until after your spouse passes away.
Yeah.
Or if you have a minor child or a disabled child up to a certain age, we won't take it then. But we are going to take the house.
Yeah.
Exactly what the statute says. Or force the sale of it, or work out a deal. But we're going to recover whatever we can possibly recover. Now, like you said, if it becomes insolvent, there's just nothing they can do. That's
Right.
why they get caught recovery.
There's nothing to
They
collect.
take what they can get, and move on. But
Yeah.
real estate is something they always will pursue because they can always get something from it.
Yes.
Even if it's not worth much, they'll get, you may have a $200,000 bill and a $100,000 house.
Yeah.
I mean, they'll get something out of that.
Yeah.
Then they move on. So that's what estate recovery is all about. And it's a real sleeper. And so when people tell you, don't worry about when you're getting eligible, the house is protected, and then it's not protected. They're coming after it, just not during life. And there's a lot of reasoning why it's that excluded asset, but we won't get into that. But so when we do our planning, we always think about that with the real estate.
Sure.
A lot of times we'll just use the exclusion to our benefit at the application process. Then when we get the approval, then we'll do something with the house and deal with it.
And that's the key part.
In other words, we don't want to have the person pass away owning the house. If we do, state recovery is ripe and now knocking on the door.
Absolutely.
But if you don't own it, you're passing. And we have to, depending on who's in the family, we may have to give it away, or
Sure.
Some people we can give it away to, and if we don't have anybody to give it away to, we can do so with a penalty period and do that half a loaf for that Medicaid compliant annuity we were just talking about.
Yeah.
It's something similar we did with your father-in-law.
Yeah.
With the money for that. Yeah. Or a family member can purchase it at extremely low value because the way that Medicaid compliant annuity works. Somebody can get it for, depending on the other assets, you can get it for almost half of the fair market value.
Yeah. That you might, if you want to, explain a little bit more about how that Medicaid compliant annuity works. Because to me that seems a little complicated.
Well, it's a little number heavy.
Yeah.
So on radio, that makes it on radio
Yeah.
hard to do. But if I can use good round numbers, I'll use numbers like this. Let's say you got a $300,000 house.
Okay.
And you're
I'm gonna try to keep up.
Okay, you're a single person, which means there's nobody you can give it to. We can give it to a spouse and protect it with a swoop of a pen on a deed,
Right.
because you can give the unlimited amount of money to your spouse,
Right.
and not impose and not get a penalty period.
Okay.
Okay, remember I've said before, there are only two people in all the world you can give stuff away to and not incur a penalty. One is a spouse, and the other is a disabled child.
Right.
Now, I mean a documented disability. All
Right.
children are disabled.
Yeah.
It needs to be a documented disability, right? But if you don't
We have nobody to give it
I'm
to.
saying we don't have that person,
Okay.
right? So what we do is this $300,000 has to be the fair market value, which in Tennessee is under 10-care is going to be the tax appraised value on the tax card.
All right.
Which is usually a little bit low from what you can sell it for, depending on where you are in the 5-year census cycle, right? Like the census is going to re-up next year in 27. So right now you're probably farthest away from what that value is when you sell something.
Yes.
But then they'll bump it up. So anyway, so let's say that value on the tax card is a nice even $300,000.
Okay.
What we can do, so let's just I'm going to demonstrate how you can get the house at low cost.
Okay.
So let's just assume there's somebody in the family that really, really wants the house. They don't want to lose it. It's family house and they're sentimental and whatever. They definitely want to keep it. I was raised in a house and I want my kids to be raised in a house. So I really want to hang on to this house. But the house is definitely exposed if we don't do anything.
Yeah.
If the person goes into care.
Yeah.
So we can take the house and we can, and when I explain this, it's going to sound like money going here and coming back and turn around and going back again, back and forth. Makes it easier to understand when I say it that, but when we actually do it, we can just jump right to the end and do it. But that'd be confusing. So what we can do is, let's say you have a son who wants the house, and he's got some wherewithal. I mean, he's got the ability to buy it. So what we think of it this way: he can hand a check to his dad for $300,000, and he's bought the house. Now, Dad's position has not changed one iota. He had an asset worth $300,000. He still has an asset worth $300,000, right?
Right.
Had the house. Now he's got the money.
Now he's got the money.
So his position hadn't changed. Now ownership resides with the child. Like again, a lot of people say, well, what if the kid doesn't have $300,000? Well, I'm playing it out as if the money goes back and forth. You don't need that much. So the dad has $300,000. Now he has the money he has to get rid of. Nobody can give it to. Now there was no penalty imposed because that was a fair market sale value for value. You didn't gift anything away.
Yeah.
If he'd sold it for less than the 300, it would have been a partial gift.
Yeah.
But anyway, so he's got $300,000. So now he's gonna do something that we're allowed to do under the 2006 Deficit Reduction Act that allows you to gift away a portion of money and retain a portion of money. So that I'm going to use the numbers 2/3 and 1/3, okay? Because that's where the percentage hover around. But sometimes it's a little bit lower, but for radio purposes, it's okay. So he's got $300,000. He can give his son $200,000 as a gift. Okay. Now, how much is the son out for the house at this point?
Only 100.
Only 100 is right. So he gifted that. However, by Dad gifting away $200,000, he's creating a penalty period.
Yes.
Because we're going to file the application here just a couple of days after doing this.
Yeah.
So that gift is definitely within the last 60 months.
That's right.
Okay, so, and we know we're doing it. It's like, why are you triggering this penalty period on purpose? Well, stay with me. We are doing it on purpose. We're trying to take advantage of the penalty period, which is a hard thing to do, but you can't. Now, he's given that away, but now under the Deficit Reduction Act, he's allowed to retain a portion that would be used to buy a Medicaid compliant annuity that will pay for the cost of care for the length of time of the penalty period that he created by giving away the $200,000.
Okay.
So think of it this way: you give away $200,000. Now we want to figure out what the penalty of that is. It means you got to divide it by $8,846.10. So that's going to be. Do you have a calculator?
I do.
Okay, 200,000.
Let me find it first.
Oh, it's on your phone. Okay.
I got to find my calculator here. Here we go.
200,000.
So we got 200,000
divided by 8846.1.
8846.1.
And round the number off.
22.6.
Okay. So it's 22-month penalty period.
22 months.
22-month penalty. So he takes the $100,000 that he has left.
Okay.
That coupled with his income, because remember, income always goes to the cost of care.
Right.
So let's say he gets $2,000 a month income.
Okay.
Now, when we calculate the number, you just calculate it. We take into account the income, we back calculate it, we get the number. But we're just using this example. So he buys a Medicaid compliant annuity, so he pays his $2,000 for the next 22 months, or for the whole time he's in a nursing home. His $2,000 goes to the cost of care.
Okay.
But for the next 22 months, his $2,000 go to the cost of care. And he has to private pay because he created a penalty period where TennCare won't pay.
Right.
It's a period of ineligibility. So the annuity is designed, and we back calculate it, so it will pay the rest of it.
For 22 months.
At the time the 22 months expires, so does the annuity because it's exactly timed with the penalty period. Now, at the end of 22 months, he's now eligible. Why? Because he either gave it away or he spent it on the annuity. And
Yeah.
the 300,000 is gone, so now he's eligible.
Yep.
So now, at this point in time, the son is out. The son got the house for $100,000.
Yes.
$300,000. He's now got it for 100.
Right.
Now, it could get even better if the father passed away before the 22 months was up.
Yes.
There's still money in the annuity, right?
Yes.
Now you can name as a beneficiary the son,
Yes.
because while you're private paying, normally on these things, you do have to name the state of Tennessee as the primary beneficiary, but they would waive the beneficiary because they've not paid anything for you yet.
Yes.
It's technically private paying for 22 months. So let's say we're 11 months into that, halfway, and you pass away. Well, the first beneficiary, state of Tennessee, we send them a release and they say, yeah, we don't have a claim on him because he never applied for care.
He never got any.
We never paid a thing for him.
He never had the benefit.
And so they go to the next beneficiary, which is his son. So let's say there's still half of that $100,000 in there, $50,000, and he's the beneficiary. So now how much is the son got out of pocket for the house?
Now I understand.
He's got, if 50,000 goes to him, if that's the case. Now, 100 is what it probably would be, but if a person passes away early, they get whatever's left in that annuity.
Yeah.
So we don't know about that. We
Yeah.
don't know how that's going to work. We know they're going to.
Right.
So, and again, now, it doesn't have to go back and forth like that. If the cost, all we have to do is have the son pay the $100,000, which is the cost of the annuity. Okay.
Yeah.
Or I'm sorry, yeah, and then so we don't have to go him give a check for 300 and turn around and give him $200,000 back,
Yeah.
and back and forth. We can jump right to the end financial result.
Sure.
And that's of course when you explain it that way, you kind of lose all of what's going on in the middle. It's much easier to understand when you see the back and forth.
I got it.
So
I think I actually got
and
it.
so it's we still create a penalty, you still have a period of private pay. But
Right.
we have seriously mitigated that private pay amount of time, like
Right.
because it was suppose you don't do anything. The $300,000 is all gone. It's lost
Right.
because it's going to go to the cost of care. The house is gone. The son owns the house, but he owns it for the full value, and he just uses the $300,000 cash for the cost of care.
Yes.
That's all. When I say gone, it's gone as far as staying in the family. It goes towards the service
Right.
of the home, but and so that's I use the number 300 because the percentages kind of work out 2/3 and a third.
Yeah.
Hover around there. It changed. There's
Right.
several factors in that, but it's kind of in that ballpark.
Perfect.
I see it hover a lot around 60. But it's
Okay.
I didn't want to talk about 60/40. I just thought 2/3 and 1/3.
2/3 of work.
Yeah, that's the basic concept. So it's a pretty grand strategy when you're down to what you have to do.
Interesting.
So it's better than doing nothing. It's a lot better than doing nothing. I mean, if you have $300,000, you can save 2/3 of it. That's
Yeah.
better than not saving anything, right?
Yeah.
So,
Exactly.
I mean, some people say, yeah, but we're going to lose that third. So, yeah, you're going to lose that third, but it's the half empty and half full. We're going to
Yeah,
save
yeah.
2/3.
Yep. Carl, we didn't mention we could take phone calls, but I guess we can. 766-9393. Been an interesting conversation so far. I think we got probably one of our regulars calling here. Good morning. How are you?
Yes, I have a question. Is whether he's ever run into any assets that cannot be put in a trust. And I'm throwing this out as way out because I don't know anybody. But I use AI a lot, but I found that I get really good results when I put be real specific. Like I've had some issues with a retirement account. If I put the name of the company in, then generally AI only pulls up things from their website as opposed to just in general. But I was listening the other day some advice, financial advice to people that are buying into these new currencies. And specifically, they said Bitcoin, there was no legal anything regarding, it sounded like wills or whatever. I wondered, was that true? Now, this had nothing to do with what I just said. I'm just saying, I just got to thinking, are there any assets that he's ever run into that they absolutely could not put in a trust or figure out what to do with? Thank you.
Okay.
Okay. Actually, let me qualify because there's a little terminology that has to be cleared up. If it's an asset, you own it. And if
Yes.
you own it, you can put it in a trust, whatever it is.
Okay.
But here's where it gets confusing. And she even mentioned it. People say, I got a 401k plan. I got an IRA. I got a retirement account, right?
Yeah.
And so you cannot put that into a trust. And the reason is, let's put some numbers here. Let's say I got an IRA. Been putting in it for years, and now with the administration, it's going like gangbusters, right? So I got $500,000 in my 401k, or a couple $100,000, right?
Right.
And you cannot put that into a trust because you don't own that $500,000. When I say
Which-
that, people are about to climb over the table and strangle me and say, "Bull, I got my money in there."
Yeah.
What you own, what you signed up for, what your contract says, what you own are the future stream of income, the payment. When you start getting distributions from that IRA during your retirement years,
Yeah.
they start paying it back to you every month, right?
Right.
That's what you own. And you can't so it's technically not an asset, because if it's an asset, it's something you own. And
Yeah.
if you own it, you can put it in the trust. If it's a piece of land, you can put it in the trust. If it's money in the bank, you can put it in the trust. If it's a boat, if it's anything that has the asset can be put into a trust.
Right.
But some things cannot be put in trust because they're like future income.
Yeah.
You can't put something in that you don't have yet.
Right.
Now, when you let's put it in perspective. If you let's say you got $300,000 in an IRA, you could put that 300 in the trust if you cash it out and put the lump sum in. But now you're not putting an IRA in the trust. You're putting a lump sum of cash, right? That's the only way to put it in. Of course, things go with that, like the tax burden and stuff like that.
Right.
But you could certainly put it in, but you got to change it from a future stream of income to the lump sum.
Right.
You got to surrender it, put it in. So I just want to confuse those things, but you can put any asset in. I mean, we put in things like mineral rights and stuff that some of the assets are really intangible and nebulous.
Right.
Hard to kind of like Bitcoin. It's like something floating through the air, you know. But you can since you mentioned Bitcoin, if you put Bitcoin into a trust, but what you have to do is assign something that's called your wallet. When you have Bitcoin, you have something called a wallet, and that's kind of where it's held.
Yeah.
It'd be a likened to the bank account with the bank.
Yeah.
And so we don't know how much Bitcoin's in there, but whatever's in there, the wallet's in there. So if the wallet's in the trust, then all the Bitcoin's in the trust.
Yeah. I've never made any real attempts to understand Bitcoin.
Well, I have, and it's hard, and we need to, because they're talking about the United States being the digital currency, cryptocurrency capital of the world.
They are,
because that's probably where things are going, against all this old school thought people, but it's probably likely going to be some form of that we're headed to. So we probably ought to learn it, but yeah, we can put that in, but you have to put that wallet in.
Okay.
Because it's a value that's just kind of in the ether.
Yes.
But anyway, I hope that answers the question about what if I ever run into an asset.
I think
if it's truly an asset, we can put it in.
The surprising part of that is the part where you say you don't own your 401k.
Yeah, you don't own the money in there.
Yeah.
I mean, once I explain it, then they're okay with it. Say yes, because that's exactly what we bought.
Yeah.
What we said was, especially if it's qualified funds, meaning tax deferred.
Yes.
If it's a Roth, it's still a future stream of income. But the IRA, what we signed up for is this: we're going to put money in this every month or whatever we put for years.
Yeah.
And we're not paying tax on the money. Here's the carrot, right?
Yeah.
The carrot is we're not going to have to pay tax on it. So I'm going to put $500 a month into my IRA.
Yeah.
I'm not paying tax on the $500, and it's just going to accumulate. And then your employer will match some and all that stuff, and it builds up. And a lot of people have been building up for years and years. But when you signed up for the IRA and the contract, it's okay now. I can't take distributions, and I can't take the money out before 59 and a half years old. I mean, I can, but I get hammered if I do, right? There's those penalties.
Well, I have one I'll throw at you.
But now I have to take it at 73.
Okay.
So if you take your distributions, now it'll pay you the distributions, but now the tax is owed. That's what we signed up for.
Yeah.
So you try to put that's why it's a beneficiary driven instrument. If you pass away and you still got money left in your IRA, you have beneficiaries to where it's going to go to.
Okay. All right.
So you have one.
If you have a corporation, a company, I have a company.
Mm-hmm.
Can it be put in the trust?
Yep, we do it all the time. LLC or partnership or
All right.
corporation.
If the company owns vehicles and assets like that, is that
on our revocable living trust, we typically put those things in.
okay?
That's personal property, and we can put that in. Yes.
Okay, that's what my question was, like personal property stuff that leaks around in that
Sure can.
within that company or something.
Now we kind of do that with. We don't have to itemize everything in a 900-page Excel spreadsheet. You know what I mean?
No.
We just we put all that's personal property. That's what I call your stuff.
Yes.
Things you own by virtue of possession.
Yes.
You can't prove ownership of it, but you own it because you possess it.
Yeah.
So and it's a snapshot in time, because you might think, well, ownership of personal property is a constantly moving target.
Yeah.
I like to say every Friday, like I did this morning.
But large companies would have, like, you know, a construction company, for instance, with big equipment or something like that. This personal property there is a lot of assets.
Right. I mean, but we're talking, those are corporate assets, but yeah, they are the ownership.
Yeah.
And
Okay.
with people, we can put, you know, your tractors and your cars and your trucks and your boats into the trust.
Farms.
That's real estate.
Yeah. Well, I'm talking about farms that are incorporated. You know, they get all these tractor equipment and all that kind of stuff.
Now, if it's just a loose partnership, it's not an actual business entity.
Yeah.
Meaning an entity that's created with the Secretary of State. Typically, you see people doing the LLC.
Right.
What we just do is an assignment of ownership. Now, we can only put in what you own. So let's say you own it with somebody else, 50-50. We can put your 50% ownership in the LLC.
Yeah. Okay.
And we do that. We often go to the operating agreement to make sure it's okay that you can do that. Because sometimes they have restrictions on transferring your assets in an LLC. No. And that's something we use to protect LLC property.
Stan, you make me feel smarter every Friday.
And I noticed you actually over there taking notes. I can't see, but I see you scribbling stuff down.
Well, yeah,
you said you were trying to keep up with
that the annuity thing. I really kind of wanted to understand that a little better.
You know, take the numbers with what we were talking about off mic before.
I just kind of wanted to understand that a little clearer.
And go with, I mean, if you want me to calculate that for you, I'm going to need what the amount was.
Yeah.
What the income is.
Yeah.
And what the cost of care is. I can guess at cost of care.
Yeah, we got that.
Okay.
We got that.
And
It's going to be interesting. Which is exactly what we did with my father-in-law.
Yeah.
It is what we did with my father-in-law. And you helped get that done.
And again, I mean, the bottom line is we can protect roughly 2/3 of it, or 60%.
Yeah.
I mean, that's better than nothing.
Yeah,
I mean,
exactly.
You take a lawyer to mess that deal up, right? I mean,
Somebody said, we were talking about Bible stuff the other day. And we're reading a verse of scripture, and the guy said, "You have to have help to misunderstand that."
I once heard somebody say, somebody I was who said, you know, hey, when you plant corn.
Yes.
I'm getting off track, but we've only got a few minutes left.
Yeah, we're almost wound up. About 4 minutes.
When you plant corn, you take a seed and you plant it, right?
Yeah.
And assuming you have this one corn stalk, it grows. How many years of corn does it have on it? 6, 8? How many kernels of corn are on each?
Yeah.
Cob, a couple hundred maybe, I don't know. So you get 1,000% return on interest, return on investment, right?
Yeah.
And the thing said, only a lawyer could screw that up.
Yeah.
I mean, you plant a seed, you get 1,000% return. You get 1,000 seeds in return. So naturally, you eat some, but you save. You know, in the scriptures, you save some to plant next year's crop, and you save some for people to tithe from.
Right.
You know, in the old days, if you had a field of corn. You harvest it, but scriptures say leave the outer couple rows unharvested, so the poor can come and it was a form of tithing. Let them come and get some corn for them. Yeah. Now you still got plenty to plant for next year, and you probably got plenty to eat. I mean, that's a sweetheart deal.
We have one of my local farmer friends who in big crop, in big crop, but he also plants. He usually plants a pretty good sized field of edible corn that is free to come get.
Oh, cool.
And
do you ever take a big piece of that corn and eat it raw right off the?
I have not. Well, I take that back. Yes, I have.
It's delicious. It's a little pasty, but it's delicious.
It's not bad at all.
Corn on the cob is probably my favorite vegetable.
I studied a little bit about the corn. Do you know the little tassels on the top of the corn?
The silk.
The silk.
Yeah.
Each one of those is actually tied to a kernel on the cob.
I know there's a boatload of them in there.
And if they're not pollinated, then that kernel will not develop. That's why you have these little missing rows.
That makes sense.
Isn't that cool?
Yeah, that is cool.
That's very, very cool. Corn is amazing. Is an amazing plant.
And you can have what they call straight line corn. Like in the old days, tested out at like 18-19% protein.
Yeah.
Now you take the hybrid corn sweet corn, white corn, and all that stuff, and test it out. It's less than 2%. Yeah. So it's very.
I've been told, and I'm not an expert on this at all. I'm not a row crop farmer. I'm just observing and hearing things.
Yeah.
But the most of the big row crop farm corn we see is grown for fuel and not food. Isn't that amazing?
Ethanol, yeah.
Yeah. Isn't that
anyway,
amazing?
I think we need to wrap it up, right?
We do. We got 2 minutes.
Okay, 2 minutes. So, okay, my seminar coming up. It's a little ways out, and I'll talk about it on Fridays to come. But it's not too early to sign up because people that couldn't make the last one are already signed up for that one. So, but it's going to be at the Star Theater. We got a lot of room, and so we can hold a lot.
Absolutely.
But it's going to be September the 12th at 10 o'clock in the morning. We call it Wills Trust in the Nursing Home, and that's what we're going to talk about.
Yeah.
And If I feel under the weather, Jeff will show up. And
I would encourage you. I got to go myself. We took my family, and I would encourage you to do it.
yeah, and so they do that. If you want to talk to me about anything that we talk about, I mean, anything estate planning, call my office at Pierchoski Estate Law, Pierchoski Elder Law at 931-363-7222. Or you can go to my website, which is Estate Plan Stan. There you can see the calendar and see where I'm going to be, or set your own appointment. If you want to talk to me with what we call a family vision meeting, we're more than happy to do that. We're right there in a block off the square in Pulaski. Got a house there at 304 West Jefferson Street, and you can't miss us. So, we had that seminar last week, and it was good, and we're got a lot of engagement from it. And so if you got anything you want to talk about, give us a call.
Absolutely.
I'm more than happy to spend the time talking to you.
Estate Plan Stan, everybody. That's the website too, by the way.
EstatePlanStan.com.
And I would encourage you to dig into this and protect your assets and protect the long-term care of your family and yourself. How about that?
Keep your family out of court and out of conflict.
That's right. Well, God bless, buddy. We'll see you next Friday.
Always a pleasure. Good time. Right on the money.
Service.